Thank you so much for joining today. So this seminar is about family violence prevention for partner visas. And this is a free seminar that we wanted to share with the public and to educate them with information and to empower them with the knowledge that they can actually have some entitlements if they are experiencing family violence and if their Australian partner or the sponsor using the visa as to gain advantage from this relationship that you have. And welcome, my name is Kris. I'm the Solicitor Director and the Principal of our law firm, Kris Ahn Lawyers, or Kris Ahn Immigration Lawyers. I am an Accredited Specialist, and I've been an immigration lawyer since 2011. Well, I guess there's no such thing as an immigration lawyer per se, but I am a lawyer, legal practitioner, and I've only practiced in immigration law for the past 13 years now. An Accredited Specialist just means like compared to a specialist doctors. So for any lawyers with at least about 5 years of experience, and if they pass a certain exam, then they can get the title and recognition as an accredited specialist in their field. So I am very proud to be one of just under 100, or I think specifically 96 as we counted in whole of Australia to be one of them. So again, thank you for joining us, and I'm genuinely honored that to present this seminar to inform and educate all of you. So the objective of this session is to educate on family violence provisions for the partner visa applicants. It's to empower the victims and understand their rights, and also educate them that they can seek support, because I am very well, my observation is that as foreigners or migrants who came to Australia, mostly from non-English speaking backgrounds or from a very conservative culture, this family violence can be a very daunting thing, and they may not know that they have the access to support and such. So I wanted to educate that, and also show them that, look, from the abuse and hurt that you have received, you may be entitled to a permanent visa that you longed for, even without the support of your sponsor. This seminar is not for these applicants for any visas. So it is really specifically for partner visa applicants. It is also definitely not for those visa applicants with domestic violence criminal records on their character. So unfortunately, this is not for you. If you are, you'll feel free to stay. But again, this is just to educate those partner visa, specifically for partner visa applicants, because there's a special provision called a family violence provision under the partner visa that allows us to, the clients to obtain permanent visa even when the relationship has broken down, if we can evidence that family violence has occurred. Before anything, I just wanted to say again, Australian government is extremely aware that there's the importance of seeking help of family violence, and the Australian government, especially of the recent times, have been promoting and investing a lot of money and resources into ensuring that everybody has adequate access to gaining support. So 000 should be the number one call if you have any immediate threats or physical violence that's been happening to you. So 000 to call the police or the ambulance. And then there is a 1-800 respect. So they're both 24 hours, 7 days, and they should be able to help you and guide you what to do next. So seeking the legal assistance from lawyers and law firms about you should be the second. You should seek shelter, you should get away, and you should make sure that you're safe and you and your other members of the family are safe. But this is important, and just please know that Australia government and authorities are here to support you. It doesn't matter what your visa status is. Okay, and the Australian government has set up a really a nice and amazing and informative website called familyviolencelaw.gov.au. So please check it out. Again, it's not specifically designed for partner visa applicants. However, it does give a lot of information about your rights and legal entitlements, possibly. Okay, so understanding family violence. What is a family violence? So family violence does not necessarily need to be a physical form of family violence. So your partner does not need to physically hurt you. They don't have to throw things at you or threaten you with a weapon of such. It can just simply be an abuse or a violence by words, or even just hurting your feelings, or just very, very indirect. The recent concept of gaslighting is a form of family violence. And Australian government, especially immigration, because we are talking in terms of the scope of partner visas, Department of Home Affairs does recognize a very, very, very broad and wide. They do accept a very wide description of what a family violence is. And you should also check out the website's link here, or you can just simply Google family violence home affairs, and their website about this family violence is extremely, extremely informative as well. And I have literally just copied and pasted that the examples of family violence that the Department of Home Affairs does recognize on this slide and the next. So the most obvious physical abuse is one of them, and sadly we do see this happening from our clients. Hitting, punching, using weapons is one thing. I shouldn't laugh, but sorry. But I have also have a client whose partner poured water, cold water, not even hot water, cold water, while the partner was sleeping. That's seen as a physical violence as well. You might think that, it's just people might misunderstand it as a bit of a joke or a play, but if it hurt you, not physically, may not be physically hurting you, but emotionally and mentally, it could be seen as a torture. It is part of a physical abuse. Sexual abuse is something that we do also see often. I know that a lot of people don't really want to talk about it, but it is something that we do indirectly observe through our clients' stories. And when you do recognize any form of violence like this or abuse like this, you should, claim that and notify the authorities, or talk to your therapist if you do have one. And most common ones that we do see are verbal or emotional abuses, harassing, threatening, and the saddest part is threatening you with respect to immigration status or deportation, or just using the things like, I have sponsored you for the partner visa, so you should do this. That is another thing. Or I'm just going to cancel your visa if you don't do this. So that is a verbal or emotional abuse that immigration really recognizes and accepts as part of family violence. Social abuse is also a few things that we do see. I guess social abuse can also be gaslighting, can also be part of social abuse, but gaslighting can come in many different forms. So it's just just recognizing multiple types of social abuse is another important part. So understanding and educating yourself that hey, this is something that I have experienced, then you should really think about and maybe write a diary whether it has happened to you or not, and think whether if it's something that the Australian government does, or talk to somebody and see whether you feel that, look, this is something substantial, and then you should start maybe preparing your case for the family violence provisions. So again, the important part here, the reasons why I've literally just copied and pasted these types of examples directly from the immigration's website is, number one, to show you that Australian government does recognize many forms of family violence. Again, it does not have to be physical. It can just be a few sentences or few words. If that hurt you, if that has affected you, then it can be seen as a family violence. So you just don't need to be keep these things to yourself. If you need to talk to somebody, then talk to go back and talk to the relevant government authorities or support people, and they should be able to guide you what to do after. The impact of the family violence, of course, not only the physical harm, but emotional and psychological effects. And this is the important part. We do have some clients coming to us and they wanted to claim family violence against their sponsor. But before anything, because we're not the mental health professionals, we do advise them to go and seek support and talk to a professional, and we get their opinions. We call it the experts' opinions. And when they tell us that, yes, they do accept that it is a form of a family violence that our client has experienced, then we can move on to the next steps. But sometimes, very rarely, sometimes these professionals recognize that it's not so much of a violence or abuse that they have experienced, but it's just a very disorganized relationship or very disruptive relationship that that they're in. So sometimes the hurt and these feelings that you may experience may not meet that threshold of domestic abuse or family violence. So again, this is why it's important that you do seek support and counseling if you do need to. And of course, it can complicate visa status. How the family violence can affect you is, especially if the visa depends on your sponsor. Partner visa, as I always tell my clients when they start this journey, partner visa generally should not be seen as immigration giving you the partner visa, but it's actually allowing the Australian sponsor to gain access to their partner. So the partner visa is actually for the sponsor, not for you. Very cold and very negative words here, but that's what the Australian government has allowed provisions such as partner visas for. However, if the Australian partner or the Australian sponsor has perpetrated family violence to you, then the Australian government does look at your story and listens to you, and then may allow you to gain permanent residency because of the harm and damage that the Australian partner has caused to you. So the Australian partner visa, if you're already an applicant, you should already know this, but this is what I was just trying to explain. So Australian partner visa works in 2 stages, if you don't already know. So when you first apply for a partner visa, you essentially apply for a temporary visa and then a permanent visa altogether. I think currently the partner visa application fee is $9,000 something. It's one of the most expensive visa application fees that we have here in Australia. Some people call it the price of love, but look, it is what it is. But I like to justify it because that one application fee, you're paying it for those 2 visas, temporary and the permanent. And the permanent visa generally comes 2 years after, or more than 2 years after the date of the lodgement, because there's a cooling off period of 2 years before the Australian government assesses your eligibility for the permanent partner visa. But if you have experienced family violence, and if you were able to successfully claim and evidence this family violence during the relationship, you may actually get the permanent visa almost straight away as soon as you've claimed it. So let's say based on the relationship that you have with your sponsor, you apply for family violence, but something happened and maybe the sponsor lost his job or something horrible happened in his life, but he or she has expressed his anger towards you for unreasonable grounds, and you've claimed that as a form of family violence. And if immigration accepted this claim, then you could actually get the permanent partner visa without having to wait that 2 years. So this is how powerful this family violence is, and this is how much the Australian government cares for the victims of family violence. The role of the sponsor under the immigration law, they're supposed to look after you. They do have a moral obligation to provide you with the financial support and housing and accommodation for at least 2 years. And this is again the reason why the Australian government does care, because they failed. So the Australian government does step in to assist you in that regard. Family violence provisions in migration law. So this is what we are talking about today. And again, when I say family violence provisions in migration law, there actually is a separate section, part of the law. We call it Division 1.5 of the migration regulations. And that whole division is about how to determine whether if there's a family violence, what sort of evidence, under what circumstances, all this that comes into play. Again, the most important thing is that I've highlighted here is even if your relationship has ceased and you no longer have support from your sponsor, you may still be entitled to a permanent residence visa without you having to do anything, without you having to apply for anything else, but other than to notify and work with the authorities to prove these your claims. So who can apply or who can gain advantage of the family violence provisions? So you must first be an applicant to the partner visa. So just because you have an Australian partner and you have experienced family violence, but you're currently holding, for example, a student visa, the family violence provision doesn't apply to you. So you must be an applicant to a partner visa. Now, if you're an offshore partner visa applicant, the regulations do specify that after applying the 309 visa or the offshore partner visa, you must have entered Australia. Now, the important thing to highlight is that you don't need to have entered Australia on the 309 offshore partner visa. You could have applied for the partner visa, 309 partner visa, let's say last month. And if you've obtained your visitor visa to come to Australia and visit your Australian partner and his family, his or her family, but during that visit, if you've experienced partner visa, then you may be able to claim family violence provision. Whereas the 820 visa applicants, or the onshore partner visa applicants, because you're already onshore, you can claim family violence anytime you've experienced this family violence and you've separated with your sponsor. Another important thing to highlight is that the perpetrator must be the sponsor. So I have had a client who was experiencing family violence from the parents or the family members of the sponsor, not the sponsor themselves. But we were able to successfully claim this because the sponsor allowed it to happen. So he didn't, his inactions of preventing it and actually just doing nothing to defend the visa applicant, we were able to use that as a form of family violence, and Australian government did accept that, and we were able to get that client's permanent partner visa eventually, but it was not an easy task. But this is why the important thing for you to note is that the sponsor must be the perpetrator for family violence. And the family violence must have happened during the relationship. So it can't be that after you broke up, as a revenge, the sponsor started abusing you. That claim immigration will not accept, because the relationship, yes, the family violence did happen, but because it did not happen during the relationship, it doesn't meet the family violence provision requirements. So that is another thing that you need to understand. So there are, again, we talked about the physical. A lot of people do think that physical family violence can only be in physical forms, especially coming from a like more conservative culture. Thankfully, in Australia, we recognize so many different types of family violence, And again, I definitely encourage everybody to go and visit immigration's very own website about family violence. And reporting violence, family violence is against the cultural norms. No, we encourage you to report, and there are so many help available, not just the ones 000 and 1-800-RESPECT, but each Australian state has their own support system. And because there are so many, I couldn't list it on our slides. But once you start researching, you will see that there are so many support and help available to you. It does not matter whether if your English is not very good, because Australian government also has free interpretation services available to you. Okay, so they will take your claims very seriously and very sensitively. So please seek help. There are a few scenarios that involve the children. If the child or the children are the victims of the family violence, then yes, most definitely you can claim family violence provisions. If you have a child with a sponsor, then instead of you have two options. You can go ahead with the family violence provision, or you can just quit this relationship and tell the department that, hey, look, I have a child with a sponsor and I continue to have access to this child. Then you can actually get your permanent partner visa, even without claiming the family violence provision, but just through the access of the child that you had with your sponsor. So there's one other scenario that you can still get the visa even when the relationship has broken down. If the child is from your previous relationship, then most definitely you can claim family violence, and then you can seek shelter with your child at a different place, and both you and your child will get permanent residence if the claims are successful. So the key steps, there's really 3 major steps to in claiming family violence. One is notify the department. So of course, before notifying, you want to make sure, I've really simplified this, but you want to make sure that you meet the requirements. So you must make sure that you have enough evidence to prove your relationship prove the relationship while you were sort of experiencing, or when the abuse have started to begin. When you do have this, and also when you have started seeking help, so it could be from the police, or it could be from therapists and psychologists or medical support, or even generally the family violence helplines, then when people do tell you that, look, you need to get away from your sponsor for whatever the reason, then you should notify the department. When you are notifying the department, you should be very clear as to the date when you believe that the relationship has broken up, and also the reasons why you have broken up with the sponsor. You can notify the department through your EMI account. Another important thing is you must, and you should most definitely have access to your own EMI account. It does not matter whether if you have engaged a migration agent or a lawyer, you must have access to your personal EMI account. In our law firm, we believe in transparency, and we always give access to our clients' own EMI account application records, because that allows them to look at what's going on. That also allows our clients to look at what we have done as their representative, or what wasn't done, what was uploaded, and whether if there's any communications from the department to us. Because that EMI account does have all these informations, and us knowing this, we encourage our clients to create a separate EMI account, so we share it. But especially for the partner visa, you should have access to that EMI account. If you don't, ask your lawyer, or if your sponsor is controlling it, then that could be a bit tricky, but I can tell you how we can overcome that issue a bit later on. But you should notify the department through EMI account, or you can email the department, or you can call the department on 131 881. That's their number. Or they even have a website for notifying the relationship breakup. So there are so many ways. So don't just hold, like, don't just hold into, just keep it to yourself. If this is happening to you, just notify them. The form, the statutory declaration form 1410, the government doesn't really necessarily need you to do this if you're claiming a judicial form of family violence, and I'll talk to you what judicial form of family violence is. But I do encourage people to start filling up this form, because it becomes like a diary. I know that it's a statutory declaration, but if it becomes like a diary, and as you start writing things down, from my observation, it actually helps our clients to recall and remember. I know that it's not easy to do so because it's a painful memory, but the more that they write down and more that they remember and more that they recall, it strengthens the application. So completing the form 1410 is, in my opinion, one of the most important part. And then submitting all necessary supporting evidence. So immigration, when they receive your notice that, hey, my relationship broke up because of family violence, they will give you a separate access to a new IMI account. And then they will allow you to provide further documents. You can email them by to the department, or you can upload it to this new access that you have gained on an IMI account. So that can be done. If you're not sure what this whole IMI account is, don't let this bother you. You don't have to have access to an IMI account, because immigration does allow communications by emails. So then I talked about judicial forms of claims and all this. So there's really two, when we're talking about family violence, not the form of family violence, but claiming family violence, there's a judicial claim, and then there's a non-judicial claim. Judicial just means that involves courts. So judicial claim really just means that if the Australian court was involved, and if the Australian court has declared that, yes, you are a victim, or your sponsor has perpetrated family violence to you, then that's a judicial claim, and that court order itself is enough for you to claim family violence, and immigration will not ask any questions after that, because the courts have determined it for them, and Australian government will just accept it as is. Whereas the non-judicial claims is where it gets a little bit tricky. It does involve statutory declarations that we just talked about, the form 1410, and then other documentations from, I briefly mentioned therapists, psychologists, or even shelters, refuge for the victims. So those are non-judicial claims. So because the courts are not involved, Australian immigration does scrutinize these claims a little bit more than the courts. So judicial evidence, judicial claims really starts off with your call to the police. Not all the time, but generally. So if your sponsor has been physically abusive, maybe he or she came home drunk and starts throwing stuff at you, throwing furniture, items, or starts physically abusing you, you should immediately call the police and let them know what's happening, so that they can intervene and they can keep you safe. And then generally what happens is they will apply interim or provisional order to protect you. So they'll separate the sponsor and you, and that sort of initiates the judicial part of the family violence. So then and when that is initiated, a court date will be set for the sponsor to attend, and the courts will then determine whether there was a family violence or not. And if they do determine, then that final court order is the judicial evidence that you will use to provide to the department. I keep using the word generally because every case could be very different. We do have cases where a court injunction from the family court is used to claim judicial evidence. So that means that necessarily there may not be a police involved. It could just be a civil matter between you and your partner, and using a family lawyer. In my experience, I haven't seen this. I know that it works in theory, but in practice, I haven't seen that myself. So I'm more used to seeing rather more extreme cases where the police had to be involved. That water incident was enough to go to the courts and obtain a final court order. So by pouring water on the client when they're in bed, when they're trying to sleep. So that was seen as a family violence. So again, family violence can be in any forms. But understandably, the police might have difficulty in proving family violence if it's not a physical form. So if it's a verbal abuse and all this, because it's he said or what she said, taking that to the court may be quite challenging and difficult. And in those cases, when we deal with emotional or verbal abuse, we more often challenge or take on the matter under the non-judicial claims. So non-judicial claims are, we don't really go with the courts, but we just use other experts like doctors, psychologists, counselors, social workers, to assist us in proving that my client had experienced family violence. So they will write us a letter or statutory declarations or medical reports, and we use those to claim and evidence that my client or you have experienced family violence. So that's one of the main reasons that because judicial claims may not be possible to obtain, we go through the non-judicial claims, but also other reasons that our clients, even though it may have been a physical form, is because our clients don't want to involve the authorities. So they don't want to call the police because of the cultural background, and they don't want their partner or ex-partners to get into trouble, even though they have been hurting you, harming them. They have this still this feelings towards them, and they don't want them to be in trouble. So they don't want to use the judicial claims, but they will go through the non-judicial claims. And also another thing is they fear repercussions or revenge. So by calling the police, they are also scared that the sponsor might do something to them at a later point. So that's another genuine reason why our clients do not call the police on their sponsors. And also, they don't want to see the sponsors ever again, or even talk about the sponsors ever again, because they see that, look, if they have to go to the courts or if they have to provide witness statements to the police, they feel that it's too much pressure on them, too much stress. So that's another reason. Another reason why I didn't put down, but I can discuss this in the case study, is I have another client who's actually broken up a long time ago, and they didn't even know that they could claim family violence, but they actually did experience physical form of family violence. But it happened so long ago that she didn't feel comfortable in calling the police, and she wasn't very sure whether the police might be able to, believe her stories of the physical form of evidence. So because of that, because of all the headaches that she foresaw, she decided to go through the non-judicial claims because it just happened so long ago. The non-judicial form claims evidence, we must have at least two types of evidence collected for us to claim. So one type could be from a medical form, other type could be from a police report. So again, it's not the triple number that you'll call and they'll initiate the judicial claims, but if you have provided like a report, filed a police report, or anything similar, then you may be able to use this. Or the most common ones that we tend to see in our practice is the medical from the GPs, and then psychologist. So after seeing the GP recognizes that, oh, you have been emotionally hurt and abused. We advise you to go and see a psychologist, so they refer you to a psychologist. So we can get a letter from the GP based on the determination, and then after a number of sessions with a psychologist, we can get a letter or a report from the psychologist. Another form of evidence that we do quite, which is relatively new. So family consultant or family relationship counselor was not on this accepted form of evidence before. I'm talking about, I think, within the last 2 years. I cannot remember exactly when it was included, but this is a relatively new form of, or new type of evidence that Australian government started to accept. So a relationship counselor can be another witness, accepted witness, who could write a report to advise that the client has experienced family violence. Another thing that I should emphasize is the types of evidence. Or let's say, I guess the most common one being the psychologist. I'm just going to use this as an example. So again, before, the Australian government would only accept a statutory declaration from a psychologist, but they have expanded a different form of evidence. So as a report or even a simple letter. Again, about a few years ago, they wouldn't accept that, but they now do. Important thing is, another very, very important thing is that these letters or declarations or report must contain these items that the alleged victim has made a claims of family violence. So they can't just say that, I'm depressed, full stop. But they must claim that I think I'm depressed, or I'm generally have social anxiety because I have been experiencing family violence. They must claim, you must claim that to the psychologist. And the psychologist must assess whether the claims of the family violence is genuine, or in their opinion is legitimate. So that's the second element. And then the third element is that the psychologist must also identify who the perpetrator is. This is because what I have advised earlier, that the perpetrator must be the sponsor. Not their friends, not their parents, not their brothers, not their sisters. It must be the sponsor. So this is 3 elements must contain within the letter, report, or the statutory declaration that you get from the psychologist. So this will form one type of evidence. So the other evidence could again be a medical report or a letter from your GP. Again, it has its own elements that it needs to satisfy. So generally what we do as lawyers is we help coordinating or communicating with these professionals, make sure that their reports and their letters contain specific the required informations that the Australian government must observe for it to be accepted. If it doesn't, then we cannot accept. The family violence claims may not be satisfactorily claimed. So this is very important. And another thing to note is that you cannot get 2 forms of psychologist letters. So you can't just go to 2 psychologists and get 2 psychologist letters to say that I have 2 forms of evidence. It must be 2 separate types. So psychologist medical, or psychologist family consultant, like this 2. It can be more than 2. That's great, but it must be at least 2 different types. The privacy and confidentiality, of course, immigration does take it very, 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 very seriously. And this is what I meant by the IMEI account. They will reset and refresh your IMEI account. So when you do claim that you have been exposed and experiencing family violence, immigration, what they do is they will remove your visa application from everyone's IMEI account. When I say everyone, that includes your lawyer, that includes you, that includes your sponsor or anybody. So your partner visa application will be removed from any and every IMEI account that's been logged or registered, and immigration will email you directly and ask you, okay, so we have removed all of your online partner visa application. Where would you like us to import your application to? So we would encourage you to set up a new IMEI account and then notify that to the government or the case officer, so they can they can give you access to your partner visa to that IMEI account. So this is to protect your privacy and confidentiality, and just in case that the sponsor has gained access to your partner visa application somehow before, this is to prevent them from knowing what's happening. Oh, another thing that I should also mention is, unless it's a judicial form, the sponsoring partner may not know that you're undergoing the non-judicial forms of family violence. So if you've been seeing a psychologist or a doctor, you don't have to tell them, tell the sponsor, and they don't have to notify the sponsor that you've been seeing them. So your sponsoring partner may not know that you are undergoing this and preparing or claiming family violence under the non-judicial claims. So I want you to, some people feel guilty for doing this and claiming family violence against their ex-partners and ex-sponsors who've been abusing them. But I always tell them, you don't have to feel guilty. They will never know, and they can never know. Immigration will never, update them or let them know, even if they make inquiries. So this is another very, very important thing. So the assessment process is, again, you notify the department. So there's IMEI account, web form, or email. Please don't abuse this email address. Please don't email the department, how's your partner visa going? And I don't speak for the department, government here, but I think there's a lot of, as soon as you send an email to this email address to the partner visa section, you automatically get an auto response, and then, it gives you all that, they will never respond to your processing inquiries or, such. So please don't do that. Another reason why I'm begging of you is the partner visa is one of the only very few immigration visa sections that allowed for email communication. They used to be for pretty much all the visas, but they took it down. I guess my best guess is simply because everybody started abusing and spamming them with get my visa, give me my visa, I've sent you everything. So please don't abuse it. I mean, I love the fact that we still have this communication medium for partner visas, especially for those who've been experiencing family violence and who are not very familiar with utilizing the IMEI account. So please use this email address when you really need it, okay? Once you notify the department, by the limitations of the law, they can only give you 28 days to provide evidence. So it's not that they're giving you 28 days because they are trying to force you, but they have no other choice. But the law really limits that 28 days. So thankfully, immigration knows that it can be quite challenging to obtain the family violence evidence, as well as the evidence of the relationship to start again. So it's immigration does understand that it can be very challenging to obtain evidence of your relationship, of a relationship that's already broken down, and also gaining the report and letters from psychologists or doctors, because they have their own schedule. So you can easily ask them, let them know that, hey, I need more time. give me more time, and they will give you more time. They even give us more time, and they don't like lawyers, but Australian government, they do understand that it can be quite challenging. But the important thing to note is that you must ask for extension of time before the due date, before the 28-day passes, because after it passes, then by law, it allows them to make a decision, and they don't even have to give you that extension of time. So please make note of these due dates. And when you do provide all of the documents, immigration, they don't immediately start assessing the family violence. They will assess the relationship first. What I mean by that is, before, one of the elements, as I mentioned before, one of the key elements that immigration needs to be satisfied is that the family violence must have occurred during the relationship. So immigration will assess the actual relationship, whether if it was a type of a relationship they will normally accept for a partner visa. So it's either de facto or spouse, married. And again, just because you're married does not mean that you satisfy the requirement. So that's another thing that you need to be aware of. And once the relationship elements are all satisfied, then they will move on to assess your family violence claims. So this could be the judicial. If you have the court order, then it's almost straight away that they'll go, yep, we accept, and here's your permanent visa. If it's a non-judicial, then they will have to go through the reports and the letters and the statutory declarations that you have supplied with them. If they feel that the claims are not strong enough, or if they have any doubts, then the department will arrange their own psychologists. So it does not mean that these psychologists work for and work within the department. There is an external psychologist that they will engage, and they will arrange a telephonic consultation assessment with you. So far in my 13 years of career, that actually only happened once to one of my clients, and my client told me that the session went for about 2.5 hours, and they were very, very cynical, and they were very critical about the questions. But eventually she did get the permanent visa. So they will have their own psychologist. So it just means to prove that just because you are claiming and just because you have the support from the doctors and the psychologists does not automatically mean that immigration will accept your claims. And when they do accept the claims, then you get the permanent partner visa. That's it. And the whole processing time, the quickest one since the notification to the actual permanent partner visa that I have represented for a non-judicial claim was about 3 months. So within that 3 months, we worked with the doctors and psychologists, and our clients obtained all of the relevant documentations, and immigration just quickly went through and granted our client the permanent visa. The longest one, I think it was about 1.5 years for me. But again, everybody's cases are different. So then there's no standard processing time when it comes to the family violence provision. Oh, sorry. Another thing that I wanted to add about the immigration referring your case to their own psychologist, this will only happen to the non-judicial claims. It will never happen to the judicial claims, because again, the judicial final order from the courts is more than enough. They'll never question that. I think we're over time, but I just wanted to go through a very, very quick success story and then an unsuccessful story as well. So case study A, I had a client who left Australia after breaking up with the sponsor. So after breaking up with the sponsor, obviously the visa, she knew that the visa, she had no chance of getting the partner visa because she broke up with the partner. Immigration hadn't finalized the application yet, so technically it was still ongoing processing, but she gave up and she went back to her own country. And through her friend, she had a consultation with me for a different migration pathway, and as soon as I gathered enough information, I identified that she may be eligible to claim family violence, and we did. So she has been seeing a psychologist in her home country, for all the depression and all that that she has that actually happened after the breakup because of the relationship. Unfortunately, the overseas psychologist report is not accepted. So what I have asked her to do is come back to Australia. And then if you want to really settle down in Australia, I want her to come back and, start gathering Australian form of evidence. And we did. And we claimed family violence and she obtained the visa. So even though she didn't, she had actually left the country, Australia, when we realized that she has the valid claims, she came back and we built her case up and immigration accepted her story. Case B is sadly something that we do see quite often is not about the drug addict part, but look, the partner visa applicant and the sponsor, they were broken up, but they formed an informal agreement that they're not going to notify the department, and if the client gets the visa, then that's it. And the sponsor will allow her to get her permanent residency. Now that should not be. You should not do that because you are essentially misleading the department or the Australian government. But in fact, this case, they had broken when they came and saw me. They had broken up for about a year, and they were living in a separate addresses, but they never notified the department. So instead of just letting this happen, we convinced the visa applicant to really collect the evidence of the family violence from all the abuse that she has experienced. She sought therapy from psychologists and social worker back then, and we used that to claim. And despite a year and a half, I think about a year gap, immigration accepted the claims and got her the permanent partner visa through the correct way, not misleading the department. And then the third one, which we do get quite a lot, is we get referrals from many forms of government-funded agencies like legal aid or other refuge for those clients who do not meet their requirements. So then they come to us and ask us for help. And this case that I wanted to refer was, she had a very manipulative sponsor. The sponsor did not allow our client to gain access to her own visa. And when the visa application was lodged and when she obtained the bridging visa, the sponsor did not even give a copy of that bridging visa to our client. And also they had a joint bank account, but it was generally our client putting in the money into the joint bank account and the sponsor using the money on her own goods. And I think they had a verbal disagreement on something, and what the sponsor did was the sponsor took out, I think, $40,000, which was pretty much all the money that was within the joint bank account out of the account, which was again mainly our client's money, and kicked her out of her home. So we quickly stepped in and we quickly claimed family violence, and she also obtained permanent visa eventually. There was unsuccessful stories, so I'm not going to tell you that every case that I take on is all successful, but this one was did take us and our client by a bit of a surprise, because when we did the consultation, everything looked like a very typical partner visa case with a family violence, and we even had doctors and psychologists confirm that our client had experienced family violence. But once we claimed the family violence and with a collection of evidence of the relationship, the department came back to us and told us that the sponsor, the immigration had evidence that the sponsor was in another relationship with another person. And our client did not know this. Well, that's what he told us, that he did not know that the sponsor was seeing another person during the relationship. Long story short, the problem that caused was that their relationship was no longer a mutually exclusive relationship, which is a legal element to satisfy the partner visa element. So because of that specific requirement and because of the nature of the relationship there, immigration could not accept the relationship part of the partner visa was satisfied. And therefore, despite the fact that our client undoubtedly had experienced family violence and abuse from the sponsor, he was not able to successfully claim the family violence under the partner visa because of the partner relationship element. So this is another very important thing. There was a recent federal court case about this mutually exclusive element, but I don't want to get into that part here. Okay, so today's session was about the domestic or family violence when it comes to the partner visa applications. I guess, long story short, the key takeaway that I wanted to explain is, if the sponsor has been abusive, violent, or manipulative towards you, you need to seek help. You may have an entitlement to get your permanent visa, and you don't even have to rely on your sponsor. And you don't have to live in fear. You have every right as a human being, and the Australian communities and Australian government recognizes and supports this. So please talk to somebody. It does not have to be us. If you don't have much financial support or much financial aid, you can seek legal aid, which is a government-funded legal support, and they do fantastic job when it comes to family violence. I had the opportunity to see their work through another client of mine for a different reason, and there are some lawyers that in legal aid, they do amazing legal submissions and amazing support. And I, have very high respects to them, because I cannot even imagine the number of cases that they handle, but they do amazing job. So, you can rely on them. And if you're eligible, take advantage. This is what I'm paying tax. I'm paying a lot of tax so that we provide to the communities, and you are part of our community. You don't have to be an Australian citizen. You don't have to be an Australian permanent resident to take advantage of these support and entitlements that you have. So seek help, talk to people, because if you don't, you will never get access to these. So that's my take home today. Does anybody have a question? If you could type, I won't read out your names, but if you could type any questions up, I'll have a look and answer anything. If not, then please follow us on our social media, and please contact us if you do have any other following questions that you didn't want to share within this public forum, and I'll be able to assist you and guide you to the right way. Thank you everybody for joining us, and again, I do sincerely apologize for the technical issue that we had with the link today. But again, this is being recorded, so we will make some edits and then we'll post it on our social media. So if you do wanted to revisit this session, you can always access it online. Thank you everybody. I'll conclude our session today.